is an appeal in the matter of Doorstep Dispensaree Limited and the Information Commissioner.
Mr. Cobble.
Thank you. May it please your ladyship and lordships, I appear with Mr. Clapp for the appellant. My learned friends, Mr. Jaffe, King's Counsel, and Mr. Lockley appear for the respondent, the Information Commissioner. Your ladyship and lordship should have updated skeletons from both parties. You should have a core bundle, 225 pages, a supplementary bundle, and a further supplementary confidential in part bundle.
Yes.
And there are a couple of things which have been handed up this morning, including from me a copy of the ICO's regulatory action policy. Your ladyship and lordships will have seen that of the 6 grounds of appeal that were advanced in the appellant's notice, we've been granted permission by Lady Justice Andrews on the first and second grounds, which you will find at page 6 in the core bundle. Those 2 grounds, my lady and lordship, are interrelated, and the first ground of appeal is that the tribunal, the first-tier tribunal, in determining an appeal to it under section 162 of the, I'm going to call it the DPA, that's the Data Protection Act 2018, against a monetary penalty notice that was imposed by, I'm going to call the Information Commission of the ICO, adopted the wrong approach. The approach it should have taken was that which is set out in section 163 of the Act, of the DPA, informed by the other provisions of the DPA and the GDPR, and that's the case that we will be developing today. It is, I would submit, significant that under the Data Protection Act, an appeal under section 162 is to the first-tier tribunal rather than to a court of law or to the upper tribunal. And as we point out in our skeleton, the first-tier tribunal was created for the purpose of independently remaking decisions by public authorities. The backdrop to its establishment was the Leggett report, that's by Sir Andrew Leggett, that was published in 2001, and the government white paper which followed in 2004. The recommendations of the Leggett report were given effect to by the Tribunals, Courts and Enforcement Act 2007, which established the tribunal system in Part 1. And in doing that, the first-tier tribunal did more than just replace the plethora of tribunals and panels that had been created over the decades before. Each of those tribunals and panels charged with reviewing small areas of decision-making. Each of those tribunals and panels was attached to a sponsoring department, with the appointees often being former members of those departments. They were appointed, best intention in the world, on the basis of being familiar with the system that they were reviewing. And what was most significant about the change effected by the creation of the first-tier tribunal is that it is a tribunal independent of any sponsoring department. It's a tribunal administered like this court by the Department of Justice. And a central objective which informed the Leggett report, the white paper, and the material with which the bill was introduced into Parliament, the central objective was to move away from tribunals and review panels that looked to their sponsoring department to get the steer, and that was seen as getting their steer from the department itself. And bringing that home to the present appeal to the FTT, in an appeal to the FTT against any of the types of notices listed in section 162 of the DPA, the FTT stands in the shoes of the original decision maker. it decides matters afresh. What it is not concerned with is marking how the original decision maker came to his or her decision. It is correct that there are limited circumstances, very limited circumstances, where Parliament has expressly stipulated that the FTT is concerned with the reasonableness of the decision below. But where Parliament has done that, it has done it in unmistakably clear language. And the most common example of that in terms of application is the First-tier Tribunal tax chamber in reviewing certain sorts of tax decisions, really relating to licence and what have you. And you find that provision in section 16, subsection 4 of the Finance Act 1994.
Is that something we should be looking at?
I don't think so. It simply makes the point that where Parliament has confined it to a reasonableness review, it says so in unmistakably clear terms. But I can, of course, get a copy should the court require it. So, the FTT starts the appeal, we say, with a blank sheet of paper in front of it. And that piece of paper gets populated by the evidence adduced to the tribunal, whether that's oral or documentary or both, as well as by any concessions or admissions that are made along the way. The FTT then listens or reads the parties' submissions based on the evidence that's been placed before it. And having done so, the FTT determines for itself whether the statutory criteria for the making of the decision are met, applying any applicable statutory policies and exercising afresh any discretions provided for in the legislation, and thus yielding a fresh decision. And turning to the particular appeal with which we are concerned, an appeal against a penalty notice under the DPA, that process involves three separate questions. Those questions are the same questions that the primary decision maker, the ICO, had to ask herself under section 155 in issuing a penalty notice and in prescribing the amount of that penalty. And turning to section 155, which is in the bundle of authorities under the first tab, so it is in the print at page 29, starts at page 29. Subsection 1, the first question the FTT has to ask for itself is, does the evidence that has been put before the FTT show that the appellant has failed or is failing as described in section 149, subsections 2, 3, 4 or 5. We're not concerned with paragraph B. That's the first question. Is the FTT satisfied on the evidence before it that a person has failed or is failing as described in those subsections? Then we turn to those subsections, and they are They start at the foot of page 26. And we're really only concerned with subsection 2, and to, this is not contentious, essentially make your ladyship's and lordship's life easier. What is there being said is that there has been a failure to comply with certain provisions of the GDPR.
And for our purposes, we're concerned with the GDPR, not the UK GDPR.
Yes, because of the...
Though this version of the statute obviously refers to the UK GDPR.
Yes, because what happened when we exited is that certain provisions of the EU GDPR, as it was, were altered, but they are not material for present purposes. But because the matters with which we are concerned took place in 2018, it's obviously the EU GDPR. But I'll be corrected if I'm wrong. I don't think it makes one way or the other any bit of difference to this particular appeal. Most of the provisions, the vast majority of the provisions were carried over, and every time in the Act, in the 2018 Act, it said GDPR, it was then changed to UK GDPR for whatever purpose. If we turn to the penalty notice itself that was issued, so this is in the core bundle, tab 11, page 195. We see in paragraph 2 how this worked so far as the provisions of the GDPR are concerned, because what is here identified in the second paragraph are the paragraphs in the GDPR that the ICO had said were contravened. So that's Article 514, 24.1 and 32, and then over the page, Articles 13 and or 14, in the ways that are there set out. So that, in a sense, gives everybody the lodestar in terms of where one is working to. These are the provisions that it is said there was a failure to comply. And if we pick up those, we can see what they are. The EU GDPR is tab 2. Article 5.1 states the basic principles relating to the processing of personal data. So personal data shall be, and then A, B, C, D, E, F. We see F is concerned, processed in a manner that ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing and against accidental loss, destruction or damage, using appropriate technical or organizational measures. And this is, in fact, what informs all of the provisions that are relied on. What is being said is you didn't secure properly all of this personal data. You should have stored it away in locked containers, etc., etc. And this is how you've breached it. So 5.1F we see is there's a duty on a controller, a continuing duty, always to be processing it in a secure manner. And then 24.1, about which I'll have to say something further, you see in the print.
It's this one where the first tier identifies that it can't be taken into account.
Yes, exactly. Then 32, again, page 74 of the print, it's security of processing. So taking into account the state of art, cost of implementation, etc., you've got to take appropriate technical and organisational measures. So what those measures are going to be in any situation is going to depend on the nature of the data, the nature of the organisation, and so on and so forth. And that's the task. Then 13 and 14, Articles 13 and 14, that's over the page in the core bundle. This is all about what a controller has to tell a data subject about the information. And all of us will be familiar with whenever we go onto a site that's collecting our personal information, it tells you what we're collecting, why we're collecting it, and you tick the box because otherwise you won't be able to progress anywhere on the website, etc., etc. That's how it works.
Having read it carefully.
Of course.
Having read it, yes, very, very carefully.
Yeah.
So you've got to spell out all of
Where
those things.
are you? On paragraph 14 or what?
Paragraph 13/14, both are concerned with the information that the controller has to provide. 13, where it gets the information from the data subject. 14, where it gets it from another source. And we conceded that we hadn't given the data subjects that information. But, I mean, this is a point that I'll come back to later on. At the time that the information was uplifted, less than 2 months had passed since this regime came into force. And this regime, the GDPR regime, is very different from the regime that it replaced, the
Yeah,
DPR.
everybody knew it was coming for months, if not years.
That's
People, I mean, even an organisation as effective as the MOJ, there were training sessions in advance and people knew it was coming.
we didn't say, we didn't make any excuses for that, but it is right to say, and that's why we made the concession in relation to Articles 13 and 14, it is right to say it was a learning process for all. And it's also right to say the Information Commissioner herself at the time was under a statutory duty to issue various policies regarding aspects that are set out in statute. Those took years, some of them, to come through. Nobody from the get-go was fully compliant. It was
Got to do with this appeal?
well, the relevance of this appeal is,
No, what's the relevance of that to this appeal?
the relevance is these were matters that should have been taken into account by the First-tier Tribunal in deciding A, whether to issue a penalty notice, and we'll see why in a moment, and B, if yes to the question A, what the level of that penalty should be.
But that is not a ground of appeal.
No, it
We're
is.
only concerned with burden of proof and with the extent to which the FTT can take into account what's said in the penalty notice.
That is absolutely correct, and I don't suggest otherwise, but we'll see how it informs the burden of proof question itself. Because, as I said, when one goes to section 155, so we're back in the first tab, page 29, section 1551, we're not concerned with paragraph B. So if the Commissioner is satisfied that a person has failed or is failing as described in the section. So that's question 1. We've seen how that works its way through into the penalty notice. The Commissioner may, and we say on an appeal to the FTT may, by written notice, require the person to pay the Commissioner an amount in sterling specified in the notice. And then subsection 2 informs how that discretion is to be exercised. It says that, subject to subsection 4, when deciding A, whether to give a penalty notice to a person, B, determining the amount of the penalty, the Commissioner must have regard so far as relevant to the extent that the notice concerns a matter to which the UK GDPR applies. The matters listed in Articles 83(1) and 2 of the GDPR. To the extent it concerns another matter, the matters listed in subsection 3. Now, I should, I think, here explain why it is. If you look at subsection 3, you see essentially the same things that are listed in the GDPR in Article 83. In Article 83, we have the UK version, hasn't changed from the EU version. Under tab 3, page 78, So the Commissioner shall ensure that the imposition of administrative fines pursuant to this article, respective infringements of the regulation referred to in paragraphs 4, 5 and 6, which we're concerned, shall in each individual case be effective, proportionate and dissuasive. And then it says in
Persuasive, you mean?
to encourage others to behave is what I would suggest, and particularly the individual not to repeat. That's what I would suggest dissuasive means. So it concerns the individual, but it also concerns, and these things, just to be remembered, get posted up on the internet so people can see what's been done to encourage the others, sometimes said in French. And then in Article 83.2, you see the matters that are to be taken into account: nature, gravity and duration, the intentional or negligent character, etc., etc. So returning to, we'll be looking at 83 again, but returning to subsection 1553, the court may wonder to itself, why is it that we've got both that and Article 83? The reason for subsection 3 is it's referring to breaches not of the general processing requirement, GDPR, but processing either for law enforcement purposes, which is not part of the GDPR, or for intelligence processing purposes, which is also not part of the GDPR. So it's bringing essentially or applying the GDPR principles to those other forms of processing. Because the way that the DPA works is it covers the field so far as data processing is concerned, and it splits that field three ways: intelligence services processing, which is in part 4, law enforcement processing, which is in part 3, and then general processing, which is in the GDPR, supplemented by the DPA. And each of them, understandably, has a different regulatory regime. The regulatory touch is lightest, of course, for intelligence, then for law enforcement, and then we have general processing. So 1553 is concerned not with us, we're concerned with the general processing regime, which we find in the GDPR, and that explains what otherwise looks like a puzzle in section 1552. So what we say emerges from section 155 are three questions. The first is, has the person failed or is failing as described in those subsections? Second question, the discretion whether or not to grant a penalty notice. And then the third question, if yes to the first two, of course, is what is the amount of that penalty itself? And turning to that first question.
Before you do, I'm slightly surprised that we've got this far without you referring to paragraph 163, because if you're looking at what the tribunal is meant to do, I know your thesis is that the FTT stands in the shoes of the decision maker. That's fine. I'm not concerned with that as an idea at the moment. But actually, if you want to know what the tribunal does, don't you look at section 163?
You do, but you have to.
That formulates the role of the tribunal in rather different terms to the way that you've put it.
Well, with respect, we say not. We say although the wording is at the end of the day, do you uphold the notice or you do not uphold the notice? The task to uphold the notice or not uphold the notice requires the tribunal to walk through the process based on the evidence before it. And when I opened, I said it's not simply the DPA itself, it's also the legislation establishing the tribunal itself, the rules relating to the tribunal, how it is to conduct appeals, to listen to evidence, it's got to hear parties if parties wish to be heard, and then it has to come to a decision. Ultimately, that decision is, your lordship is absolutely right, we uphold or we don't uphold, but if it doesn't uphold, and in reaching that, it starts with a blank sheet of paper. It is fundamentally different from the tasks that a court carries out when it considers questions of judicial review, which are the methodology which has been approached by the decision maker. And what that means is that the evidential standpoint for the tribunal is later than that which it is for the primary decision maker, and hence for a court in judicial review. In a judicial review application,
That's the word is.
I'm sorry.
But is.
Yes, so in a judicial review application, the court is concerned with what evidence did the primary decision maker have in front of him or her when making the decision. The fact that things emerged later on doesn't go to the lawfulness of the decision itself. The tribunal, on the other hand, looks at matters as they stand when the matter is heard before it. And that can be very different. So,
I mean, all this is common ground, as I understand it.
well, as I understand it, it is as well. And what we say, and fundamental to this question, which we say, let's call a spade, is that the burden of showing what's in section 155, i.e. that a person has failed or is failing as described in those subsections, hence in the DPA, is on the Commissioner.
This may be a really stupid question, but who goes first in the FTT?
The appellant, generally.
And is that what happened here?
Uh,
Because it's not obvious from the...
I believe so. I think yeah, Mr. Lockley and I were there. It was a virtual hearing and in the depths of dark period, yes. But my recollection is, yes, I went first. The court will have picked up that there wasn't evidence adduced by the Information Commissioner.
But at the moment, I don't accept that as a proposition, because the rules entitle the FTT to take into account, it's 15.2 of this Chamber's regulation, which you'll know better than me, stuff, even though it wouldn't be necessary. Why can't the MHRA stuff all be brought in as hearsay? It's all evidence.
Well,
it goes to weight.
yes.
Yes or no?
Well, correct. It isn't bound by the rules of evidence, but nonetheless, this is not this case. But if, for example, the Information Commissioner simply rolled up with a penalty notice and said, there you go, which is in fact what the ICO says it can do, folds its arms and says, there it is, I've got my penalty notice, then that's all that there is. The tribunal doesn't have an inquisitorial role. It's like some...
The appellant may persuade the tribunal that that is not sufficient to justify a penalty notice.
Yes, and I would suggest in the posited circumstances that wouldn't take very much because...
That's not this case by any million miles.
Well, I don't know about a...
1,000 miles.
Well, what we say is that what the Commissioner did get out of the MHRA wasn't sustained when an analysis was carried out of that material. That's what the problem was.
Just talking around it for a moment, I mean, the first-tier tribunal judge explains that she had an agreed electronic bundle of evidence comprising pages 1 to 1665. So she had that much evidence.
Correct.
And she had a statement of agreed facts. And as matters progressed, she had the evidence of your witnesses, including the detailed analysis of the material. So this isn't a case where there was no evidence. Your positive case is one where there simply is no evidence to set against your appeal.
Well, yes, but I mean, let's start with the posited case of no evidence, simply a notice, and nothing. Let's say the appellant simply folds his, her, or its arms and says, that's not good enough. What's the outcome? And we say, let us call a spade a spade. The burden is on the commissioner to show that there has been, that the appellant has failed or is failing as described in those sections. It's not good enough. And obviously that would be, particularly in this case, that would have been a rash thing to do. But in terms of identifying, is there or is there not a burden of proof, that's the way that the question falls to be answered, we say.
And I absolutely follow that. That's the first ground of appeal. What you've said so far doesn't really answer that question. I mean, it's common ground that the FTT looks at matters afresh, takes into account the evidence before it, as opposed to limiting itself to what was before the commissioner. It's common ground that it's not a judicial review test, it's looking at matters again. But it's the next question that we're concerned with.
I said there are three questions, and in relation to the first question, we don't have a major complaint about how the FTT went about it. So the first question is satisfaction. Our complaint is how it went about the second and third questions. That's when all the business about hope and glory come into play.
And I see that, but that's the second ground of appeal. At the moment, are we not on the burden of proof?
We are on the burden of proof, but I said the two grounds are interrelated. Indeed, we state that in our grounds of appeal. They're related because the burden is on the commissioner at all three stages. The burden is on the commissioner to show that they've failed. The burden is on the commissioner to show that it is just and appropriate to issue a penalty notice. And the burden is on the commissioner to show what the correct amount of that penalty should be. And it's really, I'll finish dealing with the first ground, but it's really when we get to the second and third grounds that we say the tribunal went off the rails. And I'll show this in a moment. But
You mean the second and third questions?
yes, second and third questions, I'm sorry.
The discretion of whether to issue the penalty notice and the amount
Correct.
of it.
That's where we say it went off the rails. And those two things, the two grounds, as I've said before, are related. But let me finish on the first question, And we can see that in relation to Articles 13 and 14, the appellant conceded, as I mentioned earlier on, that it complied with those articles. And just to get the reference for that before this court, it's in the supplementary bundle, page 46. At 45 is the schedule of issues that were in dispute. And at 46, paragraph 2, the court will see that we accepted that we, the appellant, had breached Article 13 or 14 by failing to provide the data subjects with the information required by those articles. But again, you see in the second sentence there, we are pointing out that this is really the issue here is one of the discretion. So that left the FTT to decide whether the evidence before it established contravention of the remaining provisions, that's Article 5.1f, 24 and 32. And we have no major complaint with the FTT itself. If we return to the decision, we pick it up at page 165, sorry, that's tab 9. Paragraph 36. You'll see what it there says, to which we don't take issue. Things get.
39.
I'm sorry.
paragraph 39.
No, 36.
36 is taking a fresh decision and taking
Yeah,
a fresh
got it.
decision.
Sorry, page 164 in the core bundle.
Okay.
Core bundle. Yes, taking a fresh decision, not required to undertake reasonableness review.
You obviously agree with that.
Yes, we do agree with that. What we do say is that the following two paragraphs.
Sorry, and the FTT have got it are correct that it's on the evidence now before.
Now before, exactly.
Sorry, I interrupted you. You're going
No,
on.
so that's that we say, in fact, I've got written in red, correct next to that paragraph. And then in the following two paragraphs, we say is where it starts to go wrong. At paragraph 38, you'll see it says conclude.
I know you do, but could we just look at 37?
Yes.
Because if
just-
you go over the page to page 165 in the bundle, the second line down, however, the weight to be attached to the original decision when hearing an appeal is a matter of judgment for the tribunal, i.e. it depends on the decision and the circumstances and what is relevant and what the test is that the FDT is applying. It's not said that this is a careful attention, put it on a pedestal, gild it with gold. It's, of course, I've got to look at it because that's what I'm concerned with. But I have to weigh it and see whether it's snowflakes or lead.
Well, that is what it says. And when we get to how the FTT carried out the exercise, we'll see how that worked out in practice in relation to these things. But we say that's wrong. That's not starting with a blank sheet of paper. That's
So
starting
you
with,
said that is wrong in any event. That
in the event of,
always start with a completely blank sheet of paper, and you don't look at all for any purpose at the penalty notice itself.
well, you look at it to see what the penalty was and the grounds and the penalty. But in terms of writing on that blank sheet of paper for the purposes of a penalty notice, you don't.
You say it comes later, if at all. I mean, we've got a blank sheet of paper. Why can't you start? I mean, we all read sets of papers differently, but why can't you start reading by looking to see what the notice says?
Well, yes, you read what the notice says, but in
And
terms
then
of
you look at everything else you've got to do, and then you make your mind up. What's wrong with
yes,
that?
you make your mind up independently of what is in that penalty, independently of the reasoning process. You're not.
You're not submitting that the FTT didn't do that in this case. Eh?
Well, I am submitting that, and we will see that in a moment when it came to the second and third questions.
So as I understand it, your submission is that no weight is to be attached to the original decision.
Correct.
And then, as I think you're just recognising, looking at how the FTT has approached this, there's no reason, I think, to believe that the FTT attached any weight to the notice in deciding on breach, so to speak.
Yes, and the way that's correct, and the way it dealt with that, it's slightly giving it the best possible reading I can in paragraph 38, where it says they conclude that from these authorities that the submission that was made by Mr. Lockley was broadly correct, and that to a limited extent the burden of proof is of secondary importance in the context of a full merits review. So pausing there, again, it's reiterating that this is a full merits review, to pick up the point that was made to be my Lord Justice Stuart-Smith. However, when the appeal is against a penalty notice imposed in response to perceived infringements, I'm satisfied that there must be also an initial evidential burden imposed on the decision maker. So that's referring to the breach aspect of it, the first question. I mean, it might be a counsel of perfection, but I'm not sure that speaking of evidential burdens, shifting, what have you, is all that helpful. The reality is the burden lies with the Information Commissioner to show the breach. You put forward evidence to discharge that burden. If nothing is said by the appellant, then that stands. If something is said by the appellant that's put forward, then it needs to be balanced. Then ultimately an evaluative conclusion is reached by the tribunal to say, where does it fall?
So you agree with paragraph 38, in fact?
Well, other than sort of nitpicking about the
Other than
language.
nitpicking, you do.
Yes, I mean, we say
Yes.
the burden is always with the commissioner, but you discharge that burden with sufficient evidence, not just any old evidence. And you'll see that the evidence,
Sorry.
the evidence that was said to be sufficient was the notice itself. And that's what we say doesn't work.
Can we just disentangle things? I mean, at the end of the day, given the grounds of appeal, we have got to address ourselves to whether, in principle, you're right that the burden is on the commissioner rather than the appellant. But coming back to the facts of this case, do you say that the burden played any role in relation to breach questions?
No, because I've already said that as regards the first part of section 155, i.e. that we failed, it's gone about it in sufficiently correct way. Plus they had the concession, let's not forget, in respect of Articles 13 and 14. So we're in there.
So can I just break it down for a moment? So that's the first question. I'll just make a note before I ask the next one. So coming on to the second and third elements, and I follow where you're going to in relation to the second ground of appeal, because you say you can see that the FTT did attach some weight to what the commissioner had said. But when you get onto the second and third grounds of appeal, I'm not quite sure how the burden of proof really comes in, questions. I'm not really sure how burden of proof comes into it. I mean, you've established that there's been a breach on this hypothesis. You have to decide what the whether it's appropriate to impose a penalty, and if so, what? Well, where does proof come into that?
Well, it's burden of satisfaction, shall I put it that way, is perhaps a more accurate description. The burden of satisfying the tribunal that a penalty notice should be issued lies on the commissioner. The burden of showing what the number should be lies on the commissioner as well.
So can we just boil that down?
I'm not receiving a favourable response
Well,
from
can we
far
just-
right.
Don't take any notice of my face. I can't do anything about it. Just keep going.
Can we just boil it down a moment more? So the tribunal gets to the point where it says, okay, I know there's been a breach, and now I have to decide whether there should be a penalty. I can quite see that if you're right about the second ground of appeal, there's something to be said about taking into account what the notice has said. But this idea of a burden of satisfaction, I mean, it just feels unreal. And or at any rate, how do you see that playing out here? What's the reason to suppose that the FTT got it wrong because it proceeded on the basis that it was for you to satisfy them that there shouldn't be a penalty?
Well, let's get cut to the quick, shall we? Page 185 in the core bundle. Well, let me start at page 182. So, general conclusions. And at paragraphs 81 to 82, you'll see that the tribunal is concerned with evaluating the evidence before it in respect of the contraventions. So it records that where it got the evidence, what the commissioner's evidence was. It records the fact that the commissioner thought there were 9 times as many or so documents containing personal information than in fact were carried out. And then in paragraph 82, records, in a sense, the facts, matters and circumstances surrounding why what had happened. Then at 83, you see the conclusion reached in respect of Article 51F, that is a contravention, non-compliance with 51F. In 84, there's reference to 51E. And in 86, Article 24, and that falls into the sand, and then 87 records the concession. So at this point, all question one.
Can we just cut to the chase, to use your phrase? I don't understand you to be in a position to challenge any of those findings of fact.
Not doing it, don't want to.
You don't want to.
No, don't wish to.
You're happy, you accept. There's nothing in 81 to 87 that we should be crossing out.
Well, fineness of language, but you know, nothing that sustains the appeal.
Okay.
It's the next bit under the heading monetary penalty notice, 88 to 96, to which we take exception. Because these paragraphs, 88 to 96, are concerned with the second and third questions. And the second question that the tribunal had to decide for itself was whether, as a matter of discretion, giving due regard to the matters listed in Article 83(1) and 2 of the GDPR, it was satisfied that it was appropriate to impose a penalty on the appellant. That's what the second question was, and it had to answer that question by reference to the evidence placed before it and any concessions or admissions. And Section 155 contemplates that there will be situations where there has been non-compliance, but it's not appropriate to issue a penalty notice.
And that must be routine. I mean, there must be all sorts of occasions when a document goes astray or whatever, so there's a breach and there's no question of issuing a penalty notice.
And if we have a look at the regulatory action policy, which is referred to by the tribunal in paragraph 92, which should be in front of your ladyship and lordships.
Just, I'm sorry to interrupt you. Just before you do that, so that I've got it straight in my head. Section 163(3), if the tribunal considers that the notice or decision against which the appeal is brought is not in accordance with the law, that's one thing. And then we're on to the second one, B, so that we can focus where we are. On B, to the extent that the notice or decision involved an exercise of discretion, and here it does, whether to issue a notice or not, have to decide whether the commissioner ought to have exercised that discretion differently. Okay, so you're looking at how it was exercised, and you're sitting in the position of the FTT whether it ought to have been a different conclusion in relation to that exercise of discretion. So I'll just have that clear. Please go on where you're going.
So that we say is a merit review. So in the regulatory action policy, it's page 23 down to 25.
From penalty notices on
The penalty notice starts, my lord, at the bottom of, because it's considering all of the various notices that can be issued, enforcement notice, information notice, what have you. Penalty notices starts at the foot of page 23, and your ladyship and lordships will see that it mimics the language of Article 83(1) and 2. And at the foot of page 24, it says, in the majority of cases, we will reserve our powers for the most serious cases, representing the most severe breaches of information rights obligations. These will typically involve willful, deliberate or negligent acts, or repeated breaches of information rights obligations causing harm or damage to individuals. In considering the degree of harm or damage, we may consider that where there is a lower level of impact across a large number of individuals, the totality of that damage may be substantial or may require a sanction. And that, of course, is relevant here because there were many people whose records were in the particular records themselves. But that goes to the fact that that distinction, there's been a contravention, should there be a penalty notice, is a real one. It's not one following the other as night follows day. But as I say, it's in these paragraphs that what I've called questions 2 and 3 fall to be, were considered by the FTT itself. And what we say is that it was for the Commissioner to put forward sufficient material before the FTT, directed to the matters that are in Article 83(1) and 2, and also in the policy as we've just seen, to convince the FTT that a penalty notice would be effective, proportionate and dissuasive.
But it's not limited to what the Commissioner puts forward. You're contemplating a stage where there's been a full merits review, all the evidence is in from both sides, all the materials there, and then the questions start to be answered one by one. We're now on question 2, should there be anything? It's not, but to my way of thinking at the moment, it's not helpful to just simply reiterate the Commissioner must put this forward, because you're looking at a stage where there will be, as there was in this case, relevant information from both sides.
Yes, I'm happy to take that point. Absolutely happy. And what we say is that when it came to the second question, indeed the third, the FTT went about it in the wrong way. So the paragraphs here, 88 down to 96, in fact, deal with what I've called the second and third questions together. And
Well, is that fair? I mean, 89 seems to deal with the second question.
correct. Well, you'll see that. I mean, again, it's a counsel of perfection. It's not a ground of appeal. That is something, and in particular, it's understandable because 83(1), the two things relate to both the fact of the penalty itself and the amount. So you can understand why it would put the two together. But we say it would have been preferable because perfection is better than imperfection. But we don't say, as I say, that warrants overturning the FTT decision. The second question, i.e. whether or not to give a penalty notice for the infringement found, you find the approach, reasoning and conclusions of this in the first 2 lines of paragraph 88, in paragraphs 89 down to 91, and then again in paragraph 93. So that's where you get the answers to the second question. And it's clear from these paragraphs that what the Commissioner said was the principle in the Court of Appeal judgment in Hope and Glory was front and centre of the reasoning process. And this is why the two grounds marry. And we can't be confident, I say, reading these paragraphs, that the Tribunal's decision on question 2 would have been the same had the FTT approached the question afresh, without feeling the need to give what it termed appropriate weight to the fact that the Commissioner had decided to issue a penalty notice. And you see it in the language of these paragraphs itself. It starts by stating right at the beginning in 88, I have afforded appropriate weight to the Commissioner's decision to issue a monetary penalty notice. It's said to be in accordance with the principles identified in Hope and Glory. And then over the page, paragraph 90.
But on the other hand, at the beginning of 89, I nevertheless reach, that's after having looked at the numbers of documents, I nevertheless reach the same conclusion.
But that's because what had happened is the Commissioner, in issuing the notice,
I've got the numbers wrong.
seriously wrong.
Seriously wrong.
Um,
But it is saying, I've looked at the documents and I come to the same conclusion.
In that contraventions identified are sufficiently serious to justify issuing a penalty.
Yeah,
That's
so then
surely him exercising his judgment stroke discretion.
we go over the page, paragraph 90. There's an adoption of the Commissioner's assessment of the factors. Other than, sorry,
What's wrong with that? If he happens to think that their assessment is justifiable and right, what's wrong with that?
because it's not a question of adoption of an assessment, it's a question of thinking for yourself, tribunal, about those factors.
And then, if
Reaching-
appropriate, you might adopt what someone else has said before.
It may be a coincidence,
Well, it may be, but it's not.
but it's not expressed that way. It's an adoption.
Okay.
Adoption,
All right. Well, okay.
adoption.
I've made the suggestion.
And then you see again in paragraph 93 the
But before we
language.
go on to 93 and 90, 1, 2, 3, 4 lines down, and that goes back to the I adopt, and I understand what you say about the use of the word adopt, but I note in particular, and you're saying, oh, that's going back to the Commissioner, but it's noting what has been said in the sense of that's why I've adopted, conclusions about gravity of breach, risk and significant emotional distress, etc., to vulnerable group. So that is pinpointing specific issues that have lodged in the tribunal judge's mind.
Certainly, and it may be thought to be pernickety to be taking these points, but let's remember what's at stake here.
I'm sorry, if I also go on a little lower down, I also agree with the Commissioner's conclusion about the serious breaches, etc. So, other than the use of adopt, that paragraph does look like a process of the FTT judge thinking about the factors, which happen to be the same factors that the Commissioner thought about, but thinking about them for herself.
Well, that's not how it reads. As I was
Okay.
submitting, let's remember what's at stake here. These are penalties
Yep.
so large that are sufficient to cause a company to go insolvent. I mean, these are very serious penalties, and the court will be aware, for example, that penalties for tens of millions of pounds have been levelled against British Airways, against the Marriott Hotel, so on and so forth. And given that, it is incumbent on the tribunal, when someone goes before it, to carry out the exercise in a way which is manifestly independent, fair, and adhering to the legislative regime.
So can I just pursue that for a moment? So go back to the second sentence of paragraph 90, where I think you say, well, look, this isn't just the FTT reaching the same view, it's the FTT attaching significance to what the Commissioner said. So suppose that's right for a moment. And I know you'll take us to the authorities, but is it obviously inappropriate for the tribunal to have regard to the expert assessment of the Commissioner on that particular matter? I mean, the Commissioner is going to be better placed than the tribunal to assess the wider consequences.
No, is the answer, short answer in a word to that. And the reason I say that is this. Tucked away in the legislation establishing the tribunal is a provision which says that in appointing members to hear these sorts of case, the president of the tribunal system has to pick people who are familiar with data protection and all the rest of it. And that is to ensure that the normative element that my Lord Justice Newey has just spoken to is within the tribunal itself. That is to ensure that there doesn't need to be any such deference or some lesser word, because the tribunal members have been picked so that they have this themselves. And there's a great danger in saying that one should defer to the regulator's expert judgment, because there is no then independent pull on the regulator where the regulator gets it wrong. And with the best intention in the world, those sorts of things happen. But in our system, in this system of tribunal, that's the check and the balance. And that's why I started with saying how the FTT was so different from the tribunals that had preceded it, because it brings that independence, the complex and sophisticated regime to ensure that the members who sit in the different chambers and with the different jurisdictions have the expertise themselves to reach these questions, and they don't feel the need to look over their shoulder, whether it's at the regulator, whether it's at the commissioners of tax and what have you, because they've got it themselves. So that's my...
I mean, you'll come obviously to Huang and Ali in due course. They do encourage the idea that there can be circumstances in which it's appropriate for the expert tribunal, nevertheless, to pay some regard to the views of the Secretary of State.
And
if your blanket way of putting it were correct, as you put it a moment ago, that wouldn't make sense.
well, those were policy decisions in Ali and indeed in Hope and Glory. That's the fundamental distinction between that. These are policy decisions that are being reviewed by the tribunal itself. So yes, it does make sense when it comes to a policy decision to give weight. This isn't a policy decision. This is the application of principles that are set out in the legislation and that are spelled out the criteria that need to be taken into account. And we say that it wasn't for the tribunal to, as I put it, adopt, to be paying heed to the Commissioner's assessment. It was to consider the factors itself, listening of course to the submissions from the Commissioner on the applicability and strength of the factors in Article 83, 1 and 2. But we say unswayed by the Commissioner's assessment. And we say that the whole tenor of these paragraphs, starting with the reference to Hope and Glory, whole tenor of them is of a predisposition to follow the Commissioner's assessment, save to the extent that the appellant had been able to demonstrate some mistake having been made by the Commissioner.
And so if paragraph 90 had read, I've considered the factors in Article 83(2), and in fact, having done so, I've come to the same conclusion as the Commissioner, would that be right?
That would be better.
And I have not been swayed in any way by the Commissioner, but I come to exactly the same conclusion.
Well, I think really what I would expect to see in a decision of this importance to this company is a going through of the factors in 83(2), going through them one by one, marking them off, saying, yes, this is prevalent here on the evidence that I've seen, or this is important, so on and so forth, and then reaching a conclusion. You might say at the end of that process, I note that this...
It's the same outcome.
It's the same outcome. You might say that, but at least it's demonstrably the process that's demanded by the legislation itself.
A separate process.
And that's what we say is demanded, particularly for a penalty notice and particularly for a penalty notice of this order. And it's interesting that the only reference to the Commissioner's own guidance is that fleeting reference in paragraph 92.
I must admit, I haven't spotted the reference where...
It's in the middle of 92.
I see,
line.
that's the statutory guidance.
Yeah.
Yes, I see.
And we say the same mistake infects the third question that the FTT should have decided for itself, namely the amount of the penalty. Started, we say, with a blank sheet of paper, should have considered all of the material before it, whether from us or whether from the other side or whether in a bundle of documents or what have you, together with the guidance, And instead, what we see is it starts from the ICO's position, the FTT, and then asks whether it should depart from that. And so in paragraph 92, you see it says, having considered the Commissioner's statutory guidance and the circumstances of the case, I'm satisfied that the Commissioner's penalty assessment of the notice of intention of 400,000. So the ball for a penalty notice gets started with a notice of intention, where the Commissioner says, I'm intending to issue a penalty notice in this amount because of such and such and such and such. What do you say, person who's to receive that notice? Submissions are made, and then comes the notice of penalty. In this case,
At which point the Commissioner declares herself to be satisfied of the necessary points.
of the necessary points and of that the amount is the correct. Yes, so here we're concerned with the FTT, and what she's saying is, I'm satisfied that the penalty assessment in the notice of intention of 400,000, which for this company would have spelt the death knell, was appropriate given the facts as she understands them to be. I'm further satisfied that a subsequent reduction to reduce the penalty to 75,000 was appropriate in light of DDL's financial position. This isn't a matter for the FTT to consider. It's got to consider, is the amount the correct amount, not the process that was reached by the Commissioner.
This has a magnificent air of unreality to me, because I think that you've reached a position where if in paragraph 90 the FTT had written out each of the subparagraphs of Article 83, 2 and 3 and said, this is my independent assessment, and adopted exactly the same words as before, and said, this is my independent assessment, you couldn't criticise that. And here, if the person says, right, I'm now reviewing it, 400,000 may have been okay before they knew about the financial position on the basis of what they thought. 275 was okay, taking into account what they knew and presumably what it was before the FTT about the financial position. But the numbers are all wrong, and so I'm going to reduce it, and my assessment is 92,000, a reduction of 2/3. At the moment, although you're doing it absolutely beautifully, it all sounds absolutely marvellous, sentence by sentence. At the moment, you haven't persuaded me.
I deduced that.
I'm sorry, I'm such an open book. At the moment, my mind is definitely not closed, and I would like to understand your submissions so as to be able to grapple with them better. But at the moment, it just feels like we're talking about theories that have no grounding in this judgment at all.
Well, let me try again.
And I'm not trying to be difficult.
No,
I just don't understand it.
I appreciate the remarks. I respond well to criticism.
And Mr. Corbell, I think that what you're saying is, you shouldn't be starting from a benchmark and then whittling it down from there. You should be starting with a complete blank sheet, thinking, how serious are these breaches? What is dissuasive, etc., etc. And I come up with X. But even 92,000 is a process of coming down from 400 to 250 and then drifting further, given the numbers, and then picking up from there, because actually it shouldn't be a percentage reduction because they are serious. So in those last paragraphs, the FTT judge does consider for herself specifically whether a percentage reduction would be right or not. But you would say, presumably, she has still reached her position on the graph by reference to the 400 and has dropped down the temperature gauge and then picks up rather than beginning at naught.
As a surveyor would say, she's taken 400,000 as the datum. And then
let's not.
Let's not go there. But that's your ladyship is right. That is the problem with the approach, and it's not a question of incanting Article 83(2) one by one and then ticking them off in a formulaic fashion. This is a very serious appeal, that mark life or death for this company, as it does for other companies. And it has to be done absolutely properly, we say, and it has to be manifestly so that it has been done absolutely properly.
Mr. Cobble, could I just bottom out that you said on a number of occasions, oh, this is, you know, life and death of this company, etc. But is that a relevant factor as to what the and how should it be factored in as to what the penalty ought to be?
The answer is
Just so that I'm sure about that.
yes. The answer is that it is, and it comes about in two ways.
And did you have evidence of that?
Yes, and in fact, you'll see that.
I'm sorry, I probably should know all of this, but I just want to be
If you
clear.
see that it was picked up in the final words of paragraph 92,
Thank you. Yes, yes.
and then if you go to Article 83 in the UK GDPR, which is under tab 2 in your bundle of authorities. You'll see the various matters that fall to be taken into account.
I can't find that for a moment.
Tab,
Sorry.
tab 3, my lady, in the
Yeah.
printed bundle, it should be
Got it now,
78.
sorry. Yes.
And the effectiveness is the matter. And if we then return to the articles in question,
Sorry, we were.
sorry, 83.
So we're in Article 83. Yes, I see.
So it's got to be effective.
So it's not that it's in features in the 83.2 list. It's the effective bit.
No, but you'll see it features in the policy itself. And then
Yes.
if you go to the articles that were in issue, and in particular Article 32, so we're now at tab 2.
Yes.
You'll see it takes account state of art, costs of implementation. The pausing there, costs of implementation are reflective of the means of the body itself.
Sorry, I've
I
lost you
don't
again.
think
I'm
that's
sorry,
right.
Article 32(1), tab 2,
Yeah, no, I'm sorry.
page
I'm there now.
74.
Yes, but is this not concerned with breach rather than penalty?
It is concerned with breach, but when you marry that, if you have your hand at that page, and then also take into account the gravity, which is a factor to be taken into account, nature, gravity and duration of the infringement, we say the two things go hand in hand. So to take an example, if you've got we've got Google, which has means and all the rest of it, takes absolutely no measures. That's inexcusable. But if you look at a very, very small one-person company, etc., it's a different story, what's required of it. And that's consistent with the overall regime, and indeed is consistent with the policy itself. So,
But I mean, just circling back, this isn't a ground of appeal because we can see that the means of the company were taken into account anyway.
well, they were certainly in when the tribunal found that the commissioner was right to reduce the 400,000 to the 275,000. So it was there in front of the tribunal itself.
I'm sorry to have started this hair running. I just needed to
Now,
bottom it
well,
out.
so what we say is, as my lady has just identified, is the tribunal needed to start with that blank sheet and work out what was the appropriate penalty, or whether a penalty notice should have been issued, and if so, what that penalty ought to have been. And we say that is not manifestly apparent from paragraphs 88 down to 96.
So that's,
And,
sorry, go on.
sorry, and hence why it speaks of a reduction in the penalty. It's starting, as my lady has just indicated, with a datum and then reducing it, rather than saying this is what it should be, applying those factors. I'm sorry, my lord, I interrupted.
No, sorry. I think I've understood now how you relate your submissions to what the FTT decided. We'll obviously need to move on to your legal submissions as to burden of proof and how far it's proper to take into account the original decision maker's assessment.
Yes, so the two authorities really that these grounds of appeal revolve around are Hope and Glory and Ali Hesham, and I'll take them in turn.
So on burden of proof, are you not referring us to any authorities?
Well, the burden of proof authorities are those which I've set out in our skeleton argument. And the issue is not so much, is there any burden of proof, but whether it applied to all questions that fell to be answered on this appeal. So the three questions that I say fell to be answered, because when we looked at paragraphs 37 down to 39 of the decision, we could see there was some reference to burden lying on the Commissioner in respect of, has there been a contravention of these provisions? And then when we look at the analysis that the tribunal carried out in those first paragraphs of conclusion, that's exactly what it did do. You can take, you can say, well, it wasn't perfect and all the rest of it, but we don't take a pot at that in any way. Our issue is with questions 2 and 3, because at that point, both in the statement of principle and in the manner in which it exercised that principle, that is palpably not what it did do.
Can I just try to go back to the law? I think Mr. Jaffe is going to say to us, look, you've got this appeal, you've got to decide where the burden of proof lies. And he'll say, look at Khan, that's the answer, on the burden of proof. Now, you may say, well, burden of proof isn't really what this is about, it's about Hope and Glory. But I think we do have to worry about the burden of proof question. And Mr. Jaffe, I think, says, well, look, Khan, that's the answer.
Well, Khan is certainly not the answer. And indeed, what we say in respect of the respondent's skeleton argument is that it goes further, considerably further, than you find in the decision of the FTT itself. And that's one of the problems. He's pushing it out, he's drawing out of it and seeking guidance from this court that would go further than anything that's actually stated in the...
And that I follow, but the fact is we're here because one of the grounds of appeal says the burden of proof is on the Commissioner, and the Commissioner says, no, it's not, it's on the appellant. So I think we have got to concern ourselves with that question.
Well, we should be very concerned with the submissions that are made, because as I say, they're saying that throughout the burden is on the appellant, not simply in respect of the first point, but throughout the burden is on the appellant, and we see that.
They say when you bring an appeal, the burden's on you. So why isn't the answer to that to be found in Khan?
Well, the answer in Khan we deal with in our skeleton. It's 34C. That's the answer. Because the Court of Appeal in Khan said that on the penalty appeal, as opposed to the other appeal.
Well, that's down to a specific statutory provision, isn't it? The penalty bit. That's because the statute said so. And I think we see that at paragraph 10 of Khan.
Let's just pull out. That's 13.
Page 127.
So tab 13.
Yeah, page 127.
Yes. Thank you.
And we see in paragraph 10 there's reference to section 60, and then it says subsection 7 provides that on an appeal against an assessment to a penalty, the burden of proof as to the matter specified in subsection 1A and B shall lie upon the commissioners. So that's why, in that respect, the burden is on the commissioners.
Yes, but as we point out in paragraph E of our skeleton, what the court is doing is confirming that a statutory provision may, by implication, place the burden on the respondent to an appeal, and we see that at paragraph 73.
And that's out as true. So what is it about this particular regime that means that the burden is placed on the commissioner rather than the appellant?
Yes, and what we say is you can't transpose that as a universal principle to this regime. This is a penalty, it's a civil penalty, and you read these provisions, as indeed was exhorted by Lord Justice Stuart-Smith to me about an hour ago, on what they say, rather than what is said in a very sophisticated appellate regime that is applicable to not simply customs duties, but also to tax duties. And I indicated previously there were special provisions in the Finance Act dealing with tax appeals and what the FTT can and can't do.
But they don't bear on this, do they?
They don't bear on this, but it simply shows you the danger of taking jurisprudence in the tax sphere and applying it to a different sphere.
I mean, on the face of it, Lord Justice Carnworth is expressing himself pretty generally. Paragraph 70, the general principle, in my view, is that where a statute gives a right of appeal against enforcement action taken by public authority, the burden of establishing the grounds of appeal lies on the person appealing. That principle is well established in other statutory contexts. So why doesn't that apply here?
Well, we say because when you look at this statutory context, having regard to the amount concerned, it's not a penalty where the person penalised has secured for him or itself a benefit. So in the tax situation, the taxpayer who plays loose and fast hopes to do so in order to either escape a tax liability or at least defer a tax liability. And that's why those are facts that are peculiarly within the knowledge of the taxpayer, him, her or itself. But that isn't the case here. Sorry.
Well, why not? I mean, the Information Commissioner doesn't have first-hand knowledge at the time of what's going on with the handling of documents. That is something that the person, the target of the penalty, will be better placed to talk about.
No, not at all, not necessarily. And in fact, when one considers the very large penalties that have been imposed by the Commissioner against organisations such as, forget about the current one, such as British Airways and all the rest of it, they're all concerned with third-party criminal hacks into their system. That's what they are concerned with, and what's being said by the Commissioner is that you didn't have adequate security measures to deal with criminal acts of third parties. And I think one's got to be very, very careful for equating that with a taxpayer who has...
But if take that context, why isn't British Airways or whoever better placed than anybody else to say what security measures they'd taken?
Because they don't know, and this is a fact, they don't know what's out there. They don't know the sophistication of criminal elements, and particularly foreign criminal elements. And it's an ever-moving game to have in place the measures to protect oneself against that. And you have organisations such as the Health Service that have been subject to these criminal hacks, who have all others. And if this is to be applied to our particular company, it is also to be applied to public authorities. You simply cannot have a different regime of treatment according to the nature of and the identity of the organisation itself. And we say you've got to be very careful very, very careful before imposing penalties of this kind, of this level, because otherwise it looks as if there's disparity of treatment according to the identity of the controller itself, and that doesn't help anyone.
Just turning back to what is said by Lord Justice Carnworth in Khan, and I'm looking at 71 to 73, he's saying the ordinary presumption is that it's for the appellant to prove his case. And of course, that's just not in relation to the issue which was expressly dealt with in the legislation that my Lord Justice Newey referred to at paragraph 10. But he says that also turns on the statutory context, the nature of the appeal, etc. He says in 73, the ordinary presumption is that the appellant must prove his case. So what are the specific features? I know you've discussed it generally, but the specific features that you bring to our attention, which takes this out of this general consideration.
Well, I'll just read the second sentence of paragraph 73, and that is that he felt the need to say that this approach seems to me to be the correct starting approach in relation to other categories of appeals with which we are concerned under section 83, including the appeal against a civil penalty. So it's very much a focus has to be placed on the particular appeal itself.
Yes.
Your ladyship asked me what are the features in this appeal or penalty notices, and the first is that which I've just identified, and that is you can find, and in fact you do find, that penalties are imposed, very significant penalties are imposed on controllers for breaches that the immediate cause is not that of something of the controller itself, but of third-party criminal actors.
But that's not being said here.
That's not being said here, my lady, but we're concerned with the principle,
Yep.
because you can't change the principle according to the facts of the case. So you've got to test it by reference to the sorts of cases in which a civil penalty notice can be, and indeed has been imposed, and ask yourself, is this a safe approach to be taken?
Yeah.
And I did say earlier on, you just posit the case of those, for example, various companies that have had multi-million-pound penalties levelled against them, and ask yourself, is the approach that the Commissioner puts forward in its skeleton a safe way to proceed? I.e., here's the penalty notice. You show, you, person paying these tens of millions of pounds, show that I've got it wrong, both in terms of the facts of the breach, and bear in mind that's very difficult to do in those sorts of cases, and in the exercise of my discretion to give you a penalty notice, and in the amount. And we say, if this system is to command respect, that it deserves, then you've got to have an appellate process in which the tribunal, which is peopled by individuals picked for their expertise in these matters, comes up with a fresh decision. And far from opposing this, we say the Commissioner actually should be giving support to it, because this is what commands respect.
And so it's the nature of the beast is what you're saying. Are there any other specific features?
Well, no, other than we say that what's being suggested by the Commissioner is, in truth, deeply unattractive.
Yeah, I think I understand that.
So, just to return to the individual analysis, I know my Lord Justice Stuart-Smith says, well, you know, you could have just, recited all of these paragraphs from 83, subpara 2, and ticked them all off and said, come up with the same answer. But just to give an idea of the sorts of things one would have expected to have been grappled with the tribunal in deciding whether to grant a penalty, and if so, the amount. One would expect to see some consideration of the fact that this regime, this sophisticated, detailed regime, had only been in place for less than 2 months. There's nothing said. There's nothing said because the Commissioner didn't say anything in relation to it. One would have expected greater consideration to have been given to the nature of the business carried out by the appellant, the size of the business, the sorts of information with which it was dealing, the source of that information itself. There wasn't.
Source of the information that the Commissioner had, or source of the
No,
information that
the
company-
data, the personal data.
and why would that matter?
Because what happened in raw terms is that the material that was picked up by the MHRA was in fact a lot of it material that had been disposed of by care homes and what have you, and the care homes hadn't, as they should have done, ripped off the personal data, and instead they were simply returning those packets of medicines that are generally arranged in a folder-like fashion so that you give the patients the right amount or the right medicine each day, and they hadn't ripped off the personal details when returning them to the appellant. All relevant matters, you would have thought. Yes, of course, that sort of thing should have been done, but one can understand in a small organisation like this supplying nursing homes with medicines and then collecting the returns, that if the body returning them hadn't done what it should have done, then you're going to have to take further steps.
Mr. Cobble, I understand, I think, what you will say about it, but paragraph 90, for example, although it's by reference to the Commissioner's conclusions, there's reference to risk of significant emotional distress being caused to vulnerable group of data subjects. So that has in its scope, in fact, the source and subject matter of the data subjects and the data breaches. And that is true further down too in 94, personal data, still very large number of documents, significant aggravating factors that the majority contain personal data of highly vulnerable data subjects. So, and then again, aggravating criteria in 95. Now, I understand you will say that's all by reference to what the Commissioner had said,
Right.
but that is perhaps in shorthand referring, is it not, to the sort of information and the source of the information.
Well, no, I mean, this is just the problem, and your ladyship has picked up the passage of the sentence in paragraph 90, where the tribunal says, I note in particular the Commissioner's conclusions as to the gravity of the breach and the risk of significant emotional distress being caused, etc. And then I agree with those conclusions. Well, let's unpick what's going on here. What's being said is that people invariably in nursing homes are at risk of becoming very distressed because the packets of medicines with their names come back to a place, and there's a period of time before those packets have the labels stripped off. They are going to become at risk of significant emotional stress. And we called evidence in relation to this as to what was there, how long it was, and the fact that they were in sealed bags. And we would say, if I may say so, get real and ask yourself, are you seriously saying that people in nursing homes miles away, oblivious, I dare say, to where the packets of old medicines, the files of old medicines, oblivious of the fact that the nursing home hadn't removed those labels before they had been picked up, oblivious to the fact of where they had gone in the rear of a premises, oblivious to the fact that they were in sealed bags, were at significant risk of...
So this is actually a different point, because I've got it in my notice under the heading of nothing being said about these features which were important to a conclusion in relation to penalty. But actually what you're saying is, I think, that the FDT judge did not for herself assess these issues in a way which would be advantageous to your client and to therefore diminish them because, you know, an old lady somewhere a long way away won't know whether it's been in a car park or not. And so she should have evaluated these differently. So it's the evaluation of these issues when coming to a conclusion about what the proper exercise of the discretion was that you're complaining about.
Well, the complaint is there's simply, shouldn't mean this pejoratively, but parroting the conclusions of the commissioner, which are found in the conclusions of the commissioner, rather than undertaking the exercise and showing that you've undertaken the exercise yourself to this body which is going to be subject to the
Well,
penalty.
it's a bit like if one member of the court writes a judgment and the other member of the court say, I agree, they're simply parroting what's been gone before.
I didn't say that, my lord.
Good. Okay.
I mean, shall we just come back to the law again? So we've looked at Khan. On your second ground of appeal, it's really Hope and Glory, Hang and Alley, isn't it?
Yes, which I'm about to embark on.
Good.
But before you, and I'm really sorry to drag you.
No.
I'm still interested in sections 162 and 163. And can I just explain where my difficulty with your submissions comes from, in case you want to come back on it? The starting point, it seems to me.
Can I get out the provisions myself?
Yeah, well, I think you know them off by heart. The starting point is that an appeal, there is an appeal against a penalty notice.
Right.
That's section 162(1) or whatever it is. So the sheet isn't clean in the way that you say it is. You start with a penalty notice, which is in existence until it's set aside by a successful appeal. So if you start with the existence of the penalty notice, surely it has to be for the appellant to show why it's wrong. And that, it seems to me at the moment, is supported by the language of section 163, which says the tribunal can review any determination of fact. And that suggests you start with the determination of fact, and then someone has to say why it's wrong. And then this next is notice is not in accordance with law. Again, you start with a notice and someone has to explain why it's not in accordance with the law. And then the third aspect is exercise of discretion. Well, you start with the Information Commissioner's exercise of discretion, and then somebody's got to explain why it's wrong. And if I ask myself who's going to explain why it's wrong, which is coming to the burden point, there's only one possible answer.
Oh.
That's where I am at the moment.
Shall I
It's
look?
bugging me.
No, I'll debug your lordship, hopefully. Taking it step at a time. A penalty notice, enforcement notice, or what have you, is issued. Pausing there, if nothing is done by the person to whom it is issued, it is effective. No question about that. It is effective. If the person to whom it is step 2, if the person to whom it is issued lodges an appeal against it, okay, so calls it into question, says that it is wrong, and leaves it at that. It is wrong, full stop. Then that individual is either not properly advised or, well, can point to a decision notice which is completely wayward and has absolutely no basis. The reality is that what is demanded by subsections 2, 3 and 4, and they're cumulative, is that there's a review of any determination of fact, there's a consideration of whether the notice is or is not in accordance with the law, and there is a consideration of any discretion behind it.
You're deviating ever so subtly, but importantly, from the language of the statute. It's not that there is a review, there is a this. Everyone agrees that it's a full merits review, but it's a full merits review of the decision. And so what 2, 3 and 4, or 2 and 3 are doing with the bits that I picked out for you, is saying in that review of the decision, the tribunal may review a determination of fact. It doesn't have to, it may. And surely it's for you to say this fact is wrong.
The decision under review can be stated and is capable of being stated in a sentence here, namely, a penalty of £275,000 is imposed upon the appellant. That's what the decision is. The rest of what's in the notice are reasons for decision. And as one gets reminded frequently in the Court of Appeal, one appeals against the notice, not against the reasons.
Which is why you review determinations of fact. The rest of the notice, apart from the £275,000, involves determinations of fact, assertions which may or may not be in accordance with law, and exercises of discretion. And they, if someone wants them to, those are the bases upon which an appeal can be.
Yes, but once one makes an appeal in a merit appeal, a merit-based appeal, which everybody has agreed, bench included, is how it goes before the first-tier tribunal. The question becomes that which is posed by section 155(1. Should a notice be, you're smiling at me, I'm not sure whether that amounts to finding favour or whether it's the smile of a crocodile.
55, as I am to stick on the 162. And I mean, I think I see. Anyway, I don't want to take up an exorbitant amount of time, but you understand.
I understand what your lordship is saying, and my riposte to that is that this is a merit review. This is a merit review. The nature of the exercise, your lordship is correct. What sorts of things can be done are defined and set out in cumulative in sections. Subsections 2 and 3 of section 163, but in a merit review, what the tribunal must ask itself are the questions that are posed by section 1551 of the commissioner, in this case himself.
And just before you move on, can I, at the risk of raising another hair, check one thing? The section 163 parallels exactly, I think, paragraph 21 of Schedule 4 to the Immigration and Asylum Act, which we then see in Hwang and Ali, which we'll come to. But leaving aside the hope and glory type point, is there any learning in the immigration context as to where the burden of proof lies if you've got a challenge under paragraph 21 of Schedule 4 to the Immigration and Asylum Act?
Not that I have at the moment, but I may have something I might find something over the lunch break. And that is a hair indeed. Can I come tantalisingly close to speaking about hope and glory? Can I actually go there now? And so we have it in front of your ladyship and lordships in the bundle at tab 13. 12, sorry, tab 12. We've got the All England Law Report there. And the only reference, is just to remind this court, the only reference to hope and glory in the FTT decision is the one that I've showed your ladyship and lordships in paragraph 37 or 38, which we've looked at before. And the genesis of the reference to hope and glory is apparent from paragraph 38 of the decision of the FTT. So, namely, so it's nicely Mr. Lockley. Mr. Lockley's submission to the FTT on the burden of proof, it said, was broadly correct. And what had been submitted is that because the commissioner had evidence, he said ample evidence to conclude on the balance of probabilities that a breach had occurred, the appellant can't complain that the commissioner had insufficient evidence of a breach because the appellant hadn't been able, or he said unwilling, to explain how it had complied with its obligations. And what was being said, and you see this in his submissions, was that the Commissioner's conclusions were reasonable, and so the tribunal should determine the appeal on the basis of those conclusions, which he said were reasonable. And that essentially was what the tribunal, certainly so far as questions 2 and 3 were concerned, accepted. And I notice incidentally that the Commissioner has, what I might term, doubled down on this in paragraphs 19 down to 20, A, B and C of his skeleton argument. And thus we see in paragraph 17, a statement, paragraph 17, sorry, of my learned friend's skeleton. In ordinary civil proceedings, it is for the claimant / appellant to prove its case, unless statute expressly or impliedly provides otherwise. And then in paragraph 20, nothing in the GDPR or DPA expressly disapplies the general rule. The legislation makes no direct provision about the burden of proof, nor does the legislative scheme imply anything to the contrary. And then we see A, B and C concluding with the sentence in C, there is no indication that the Commissioner must show or prove any factual matters before the FTT. That's the position of the Commissioner. And as I said before, this in fact goes beyond what the FTT itself decided. And the learned friends and their skeleton have said that the ICO would appreciate guidance. Well, we certainly would, if this is what's been understood to be the case by the Commissioner himself. So, in Hope and Glory, so we're at tab 12 of the authorities, the Court of Appeal was considering Section 181 and Schedule 5 to the Licensing Act 2003. And Section 181...
Can we see that in the report?
Yes, it's at the foot of the very first page where the head note is.
Yeah.
Section 181 provides for appeals to a magistrate's court from certain decisions of a licensing authority under the Licensing Act 2003. And that case, Hope and Glory, was concerned with whether and on what conditions a business should be permitted to carry out a particular licensed activity, namely the sale and supply of alcohol and the provision of entertainment and late night refreshment from premises in Soho. That's what it was concerned with. And the facts are summarised by the reporters in the All England in the head note. And self-evidently, this is not a case concerned with the imposition of penalties. It's concerned with a licence. And a licence is a permit to do something that you're otherwise not permitted to do. And by their very nature, liquor and entertainment licences are very much local matters that take their steer from the feel of a particular area, the atmosphere, that those responsible for the area, i.e. the councillors, want to convey. And starting at paragraphs 13 onwards, 13 down to 25, the Court of Appeal reviewed the background to the enactment of the 2003 Act And the court's conclusions start paragraph 39, page 119 in the bundle. And you'll see at the beginning, right at the beginning, Mr. Glenn accepted, in our view rightly, that the decision of the licensing authority, so primary decision maker, was a relevant matter for the district judge, first level of review, to take into consideration whether or not the decision is classified as policy-based. The issues are quite narrow, and that is how much weight did the appellate body, the district judge, could he give to the decision of the licensing authority, and was he right to hold that he should only allow the appeal if satisfied the decision of the licensing authority was wrong, and was the district judge's ruling compliant with Article 6 of the ECHR. And then you see in paragraph 41, Mr. Mathias rightly submitted the licensing function of a licensing authority is an administrative function. By contrast, the function of a district judge is a judicial function. We say, pausing here, this is the first departure, because the FTT, although it must of course act judicially, is making, on a merit review, an administrative decision. And what's significant here about the regime that was under consideration by the Court of Appeal in Hope and Glory is that the body that made the decision, the licensing committee, comprised councillors who necessarily must come from the area of the licensing authority and who are answerable to their constituents. And that is important because that cannot be said about the imposition of a penalty under the Data Protection Act. It's fundamentally different. Councillors who comprise the licensing committee live in the constituency and they are answerable to their constituents. None of the reasoning behind the judgment applies here. And the Court of Appeal was careful to confine its reasoning to cases such as this. And indeed, it addresses this very point in paragraph 42. Licensing decisions often involve weighing a variety of competing considerations, and then it sets them out there. And this informed and was central to the conclusions reached in the judgment of Lord Justice Toulson, with which Lord Justice Stuart-Smith would say was concurred with by the other two judgments without a separate consideration. But one would like to think that what went on behind that was in fact separate consideration by each of the judges themselves. So we say that the appeal before the FTT is not such a case as that with which the Court of Appeal was concerned in Hope and Glory. Hope and Glory was concerned with the granting of a benefit, an alcohol licence. The appeal that the FTT was concerned with was the imposition of a disbenefit, a penalty. It could hardly be more different. So that really is what is to be said in relation to Hope and Glory. I turn now to the Ali Hesham, judgment, which is in, if you have two volumes, in the second volume under tab 32. And in starting at paragraph 39, you see a general statement from Lord Reid of the appellate decision making. And what the Supreme Court was concerned with in this judgment, my lady and my lords, was the deportation of foreign criminals as defined in the UK Borders Act 2007. So it certainly was concerned with a disbenefit as opposed to the conferring of a benefit. But of course it had nothing to do with monetary penalties. And at paragraph 1 of his judgment, Lord Reid set out the two questions or two issues in the appeal.
Sorry, which paragraph?
Paragraph 1, right at the outset. And we see it's another one where there's nodding agreement from all the other judges. So there are the two issues. And the court can see, this court can see immediately that the issues are not cast in wide terms, such as the nature of appeals generally, nor even, in fact, it should be observed, of the nature of the specific appeal in question. The issues were the significance of two particular matters, Article 8 of the ECHR and changes to the immigration rules to the particular appeal in question. That's what the ratio of the case is concerned with. And the appeal right in question was that which was created by Section 82(1) of the Nationality, Immigration and Asylum Act 2002 from the Secretary of State's decision to the FTT. My lady and my lords, that's summarised in paragraph 5 of Lord Reid's judgment. The grounds on which an appeal can be brought are set out in paragraph 7. In paragraph 8...
And just to be clear, so the decision is otherwise not in accordance with the law.
So incompatible with the ECHR.
Yeah.
Not in accordance with the law, and would breach, or alternatively would breach the convention. Nothing like that with which we're concerned here. And on those questions, those grounds, Lord Reid says what he says in paragraph 8. On
Just before...
sorry.
Sorry, yes, go on. Yes, paragraph 8.
So when you've got, that's what's before the tribunal. This is what you have to, these are the grounds that you have to consider. Decisions not in accordance with the immigration rules. It's unlawful under Section 6 of the MHRA. Decision is not otherwise in accordance with the law. Or the removal of the appellant from the UK would breach the convention or would be unlawful under Section 6 because it's incompatible with convention rights. Paragraph 8, on an appeal, i.e. this sort of an appeal, the tribunal's task is not merely to review a decision made by the Secretary of State. It reaches its decision after hearing evidence and on the basis of its own findings as to the facts. And the Section 86(3) is required to allow the appeal insofar as it thinks that, etc., as you see there. So,
and just to be clear, with the etc., those two bits precisely mirror our language. And although Lord Reid doesn't cite it, the legislation also had a bit about reviewing any determination of a question of fact. So it's precisely parallel, isn't it?
yes.
Yep.
And then that's, again, a common draftsman technique is to have a formula which you find replicated in various provisions, whether it's in this or any other. But importantly, the opening words are not merely to review the decision made by the Secretary of State, reaches its decision after hearing evidence and on the basis of its own findings as to the facts. So that's an evaluative exercise that it has to carry out. And next follows a section of the judgment dealing with the immigration rules. That's you'll see that set out in under the heading the immigration rules, paragraphs 15 to 18. And the opening words of paragraph 15 are actually of importance in understanding the significance and the reach of the Supreme Court's judgment. What it here says is decision making in relation to immigration and deportation is not exhaustively regulated by legislation. It also involves the exercise of discretion and the making of evaluative judgments by the Secretary of State and her officials. So, unlike the DP regime, which is the paradigm of every I being dotted and T being crossed in terms of what you've got to do, decision making in relation to immigration and deportation is not exhaustively regulated by the written legislation. There's matters of discretion, there's matters of evaluative judgments by the Secretary of State. And a perennial challenge, he says, in such a situation is to achieve consistency in decision making while reaching decisions which are appropriate to the case in hand. In other words, a parity of treatment between the various people who bring appeals. And the solution generally lies in the adoption of administrative policies to guide decision making, something which the courts have accepted is legitimate provided two general requirements are made. And then he sets out standard public law principles relating to policies themselves. Paragraph 17, Lord Reid makes an important point about the immigration rules, and that is that they are not law. They are statements of administrative practice that give effect to the policies of the Secretary of State. So, taking stock here, the court was concerned with a policy-driven decision-making power. That's what was at stake here, a policy-driven decision-making power. And then from paragraphs 19 to 23, the court sets out the changes that had been made to the rules in July 2012. And at paragraphs 24 down to 35, there's a section on Strasbourg jurisprudence. And we see Article 8, the right to respect for family and private life set out. And of course, like many of the rights in the ECHR, it's a qualified right. And the qualification in Article 8.2 includes what is necessary for the prevention of disorder or crime, which was material to the appeal before the Supreme Court. And then moving along, administrative decision-making, a heading starting at paragraph 36, and specifically how deportation decisions are to take account of Article 8 of the ECHR. And that was, of course, an issue which the Supreme Court had earlier considered in the Huang case. Then it's at this point that we get to paragraph 39 under the rubric appellate decision-making. And this is the section which is critical for the proposition that the Information Commissioner would like to extract. And that is what might be termed the generalisation or the general applicability of the hope and glory proposition to make it apply to all administrative decisions. And that, we say, simply cannot be extracted from a fair reading of the totality of Lord Reid's judgment, because we've seen earlier on what he says about how it is to be approached even in relation to a policy-driven decision, such as that which was under consideration by the Supreme Court in Ali Hesham. because the Supreme Court is not telling all administrative tribunals, including the FTT, in the exercise of its jurisdiction under the DPA, to hold back when exercising full merit review. What the Commissioner is saying is that merit review, including a merit review in the DPA jurisdiction, doesn't start with a blank sheet of paper. It says it starts with the reasons given by the Commissioner himself and respects them unless and until persuaded otherwise. Well, if this was being said by the Supreme Court, which is a radical proposition, I'd expect someone such as Lord Reid to say so in clear, unmistakable language. And instead, we have what we have in paragraph 39, and it says right at the beginning, right at the outset, the nature of appellate decision making in the context of immigration cases involving Article 8 was authoritatively considered in Huang case, and that sets the tone for all of this and the context for all of this analysis by Lord Reid. Decision making in the context of immigration cases, bearing in mind what he has said, that it's policy driven. And so it goes on. And then at 42, says an appeal under the 2002 Act is not equivalent to an application for JR. And then over the page next to the sidebar, paragraph 44, considering the issue under Article 8, the appellate authority should give appropriate weight to the reasons relied on by the Secretary of State to justify the decision under appeal. And that's because Article 8 has such significance and importance in a decision, an immigration decision that is policy-based, policy-driven, rather than statutorily prescribed. And then he refers...
Go on.
And then he refers to Lord Bingham's example in Huang.
So Lord Bingham gives two examples, does he? One is paying attention to the Secretary of State's judgment of the probability of deportation if a serious offence was committed had a general deterrent effect, and the other was giving attention to the Secretary of State's judgment that the appellant posed a threat to public order. I mean, could it be argued that those questions are a bit similar to looking at whether the Information Commissioner thinks that a breach is likely to cause...
Well, it could be said, but I don't know it could be properly said, is the way that I would put it. This whole analysis that we see starting in 39 and all the lead up to it is very much in the context of immigration decisions and the particular considerations that are applicable to appeals from immigration decisions by the Secretary of State. Pages and pages, I mean that politely, of jurisprudence from Lord Reid setting out all the lead up to the rules, where they emanate from, the importance of the ECHR, the importance of the convention, and then he starts his analysis of appellate decision-making. Appellate decision-making in this context is the lead-up. You don't cut out these paragraphs and read them in splendid isolation from what has preceded. And that's the point. 45, might be said, represents the high point of the Commissioner's case against me in terms of what he seeks to extract from this. Because he says there, it may be helpful to say more about this point. Where an appellate court or body has to reach its own decision after hearing evidence, it does not, in general, simply start afresh and disregard the decision under appeal. That point was made in the Sagnata decision concerned with an appeal to quarter sessions against a licensing decision taken by a local authority. So pausing there, that was very similar to the regime that applied prior to the Licensing Act 2003, with which the Court of Appeal was concerned in Hope and Glory. your appeal against the licensing authority went to quarter sessions, but against the decision taken by a local authority, a decision very much, as I have already said, concerned with accountable members taking an evaluative decision based upon what they know about the locality and answerable to their constituents. And then he leads on to hope and glory, where he quotes from Lord Justice Toulson, the passage we've already looked at. And he says, these observations apply a fortiori to tribunals hearing appeals against deportation decisions. Now, just pausing there, embedded in that sentence is a recognition that the nature of the appeal itself is important to the amount and whether you take into account the decision below. And he says it applies a fortiori to tribunals hearing appeals against deportation decisions. The special feature in that context is that the decision under review has involved the application of rules which have been made by the Secretary of State in the exercise of responsibility entrusted to her by Parliament and which Parliament has approved. It's the duty of appellate tribunals as independent judicial bodies to make their own assessment of the proportionality of deportation in any particular case on the basis of their own findings as to the facts that might be said to be what I call my first question, and their understanding of the relevant law. But where the Secretary of State has adopted a policy based on a general assessment of proportionality, as in the present case, they should attach considerable weight to that assessment, in particular that a custodial sentence of 4 years or more represents a serious level of offending sentence, that the public interest in the offender's deportation almost always outweighs countervailing considerations of private or family life, and great weight should be given to the public interest in the deportation of a foreign offender. What you can't extract from this judgment is something which can be ported over to a decision that doesn't find its home in a policy-based decision, that falls to be balanced against provisions in the ECHR and international conventions. It just doesn't. And that's because of the answerability of the Secretary of State at an executive level to the decision that's being made. That's why this section of his judgment makes perfect sense in that regime, but has no application to a regime which doesn't involve such considerations, but which is concerned with a detailed statutory regime that spells out in terms, not from the Secretary of State, not from the Commissioner, spells out in terms, these are the matters that you must take into account in deciding A, whether to issue a penalty, and B, in setting what that penalty is. So, yes, the one thing I can agree with the respondents, and that is it is important for this court to spell out whether and to what extent these principles apply to the FTT in considering enforcement appeals against notices. It's important not just for this appellant, it's important for other appellants, and indeed it's important for the Commissioner himself in the exercise of his powers. But we say what comes out of this, when you look at the relevant provisions, not simply a section 163, section 155, article 83, when you do all of that, the task for the tribunal on such an appeal is, as I have put it, to start with a blank sheet of paper, decide whether there has been non-compliance with one of the articles of the GDPR or DPA. And if you decide that, decide for itself whether it's right to issue a penalty notice having regard to the Article 83 considerations, and to decide for itself what the level of the penalty is. To be clear, I'm not suggesting that it's verboten to look at any part of the decision itself. That would be unreal. that the manner in which the exercise is carried out, the articulation of how the exercise has been carried out, must command the respect of those who fall to pay the penalty, i.e. that it's totally independently reached. So for those reasons, I say the appeal should be allowed. If the bench has any further questions, I was looking at the clock, but I
Yeah,
realised
the
that-
clock doesn't help much, but my watch
It's 10 to
says
1.
that you are within your time. And I don't detect any more questions. Mr. Coppell, thank you very much.
I'm grateful.
Mr. Jaffe.
My lords, my lady, this is the first appeal to this court from a decision of the Information Commissioner imposing a penalty under the 2018 Act. And of course, the Information Commissioner welcomes the guidance of this court that will provide clarity and certainty. But it is possible, listening to the argument, to feel a little bit like the boy in the Emperor's New Clothes. The difficulty with this case and this appeal is that it is quite hard to detect, first of all, any circumstances in which the arguments advanced make any difference to the analysis of the first-tier tribunal judge as approved in the Upper Tribunal. But we also say that the arguments are bad. The true position is that the Information Commissioner is a statutory regulator. I'll show the court in a moment, but the Commissioner has a legal duty of complete independence. That's the wording in the GDPR. So the independence and impartiality of the Commissioner is very different from other decision makers whose decisions are given respect by the courts, such as the Secretary of State for the Home Department, who's of course a politician. The Commissioner has the power to impose administrative fines for breach of some important rules, GDPR. No different from many other regulators with very similar powers. The burden of proof, we say, is straightforward. When making its notice, the Information Commissioner's office had to be satisfied, and that's the language we see in the legislation, of all of the facts which the Commissioner wished to rely on. On an appeal to the first tier, and of course in the appellant's grounds of appeal, that's the point of the grounds of appeal, if the appellant wished to challenge those findings of fact, it bears the burden of proving the facts which it invites the tribunal to find. And that reflects, we say, well-established principles of law in numerous regulatory contexts, dealt with both in Khan and also in Hope and Glory. The issue is also academic on burden of proof. It's extremely rare for any tribunal or any court to have regard to the burden of proof in a case in which evidence is adduced to it on which factual findings can be made. And this case is no exception. The first tier made clear and unimpeachable findings of fact, none of which are challenged in this appeal and which are entirely dispositive of the issues that were before the tribunal. And that's because what in fact happened was that the first tier heard evidence and cross-examination of the controlling mind of the appellant. Some of his evidence was accepted, but much of it was rejected. And important adverse findings were made about the credibility of his evidence and its reliability. No challenge to any of those findings. There was also the benefit of detailed evidence from the appellant's solicitor about the exact nature of the documents that were left unsecured. That evidence was accepted in full by the first tier tribunal and led to a very large reduction in the penalty. The first tier also made detailed findings of fact about the circumstances in which documents were left unsecured in the open air. There's no appeal from those findings. None of that depended on the application of the burden of proof. And the facts were found by the tribunal on the basis of the evidence. So the burden of proof was irrelevant to the tribunal's analysis. As to the question of penalty, the burden of proof doesn't arise. The burden of proof relates to findings of fact. There's a separate issue, which is ground 2, about the extent to which attention ought to be paid and can be paid in the tribunal's discretion to what has gone before. The proper approach in relation to that is exactly what the first tier did. It directed itself that it would consider issues of disputed fact and it would consider issues of penalty for itself, and they did so. And there's no evidence that reading, citing, or relying upon some of the reasoning of the Information Commissioner in the notice amounts to a skew in the analysis, a tilted balance, or some kind of improper disposition. And one can test it this way. Imagine if Mr. Lockley, who appeared below, had simply said, well, it's extremely important, because this case might end up in the Court of Appeal one day, that you, Judge, do not give any impression that you are simply adopting this analysis and that you consider it for yourself. And the judge said, well, I very much understand that. It's a very important point, and it's also quite right. But what are your submissions, says the judge, on what the penalty ought to be? And Mr. Lockley says, well, Judge, I can't improve on what the Commissioner has said in the penalty, in the notice, where the Commissioner has gone through each of the relevant factors under the GDPR and under the Data Protection Act 2018, has analysed the seriousness in respect of each of those factors, and I invite you to adopt that analysis and that penalty for the reasons given by the Commissioner. And do you have anything to add, says the judge? Well, no, I don't, to be honest. And the judge takes those submissions and accepts them and records them in her judgment. It's an ordinary judicial task. Just so happens the judge concludes that it's right, and that's what happened here.
I mean, Mr. Coppell obviously takes issue with that. And if you're developing a case contrary to what you're submitting, you find the FTT in paragraph 88 saying, I have afforded appropriate weight to the Commissioner's decision, and then turning on to 90, when we come to the second sentence, which was discussed earlier, I note in particular the Commissioner's conclusions. So it might be argued, but like Mr. Coppell does argue, look, the FTT has been frank about what it's doing. It's attaching weight to the Commissioner's decision, and in particular, it's doing so in relation to the Commissioner's assessment of the gravity of breach and the emotional distress.
Yes, and that does appear to be what was happening. It's important not to overstate it, but there's absolutely nothing wrong with that, for the reasons which were set out by the Supreme Court in no less than 3 cases. My learned friend has shown the court 2 already, and I will also show the court, probably after the short adjournment,
Yes.
the analysis of Lady Hale in NB Pakistan to the same effect, and citing the cases that have gone before. Because
Sorry,
those-
go on.
Sorry, Molly.
I'm noticing we're 1 minute to 1. So were you at a convenient break, then we would stop now. But if there's a bit more you want to say before we...
No, I'm simply summarising to say that the answer to the second ground of appeal is that, first of all, on a proper reading of paragraphs 88 to around 94, what was being done by the first-tier tribunal judge was to address her own mind to what the proper penalty was. We'll go through it, and she clearly does exercise her own mind and her own judgment. But she is also taking into account the Commissioner's notice to the extent that she thinks it contained probative and valuable reasoning, which she was, we say, perfectly entitled to do. And I apologise for going slightly over, my lord, but I hope that's a convenient moment to stop.
Yes. So we'll start again at 2 o'clock.